And let's now spend a little more time on that breach of security in Parliament attack, as it was being called, and that also at a time when the memories of what happened so many years back in 2002 are very fresh in everyone's mind. Lots of questions unanswered. How were they able to get in? How were they able to breach what was said to be impregnable security in Parliament, the new Parliament building, with so many layers of security put into it? What was in those canisters? What if it had been something more dangerous than that? Lots and lots of questions. And those questions, of course, have led to other aspects, including the holding up of Parliament and the question of how Parliament will continue to function in the winter session of Parliament. So here's a special report on everything that happened in that breach of security in Parliament.
A major security breach on 13th of December stunned Indian Parliament when two intruders threw smoke canisters to disrupt proceedings of the Lok Sabha. Visuals captured live showed a man wearing a dark blue shirt leaping across desks to evade capture, while the second was in the visitors' gallery spraying smoke. Members present inside the house told reporters that they were chanting slogans. Both were overpowered by MPs and security staff. Citing a huge security breach during 0 hour in the Parliament, the two men, including two other protesters outside the Parliament with similar gas canisters, were immediately detained. One of the intruders carried a visitor's pass that was issued from the office of BJP MP Pratap Simha, a lawmaker from Mysore. Later, the Lok Sabha Speaker called a meeting with the floor leaders from different political parties over the incident. The opposition leaders have slammed the ruling government for what they called a serious security breach in the newly inaugurated Parliament. The Delhi police has registered a case under sections of the Unlawful Activities Prevention Act against 5 accused: Manoranjan D, Sagar Sharma, Neelam Verma, Amol Shinde and Lalit Mohan Jha. Security agencies so far have not found their connections with any terror group, while the government ordered a thorough probe into the Parliament security breach incident. The Lok Sabha Secretariat has suspended 8 personnel for security lapses.
Now, of course, with disruptions in Parliament, the first thing that really gets affected and held up are discussions on some of the critically important bills that are actually there for passing in Parliament. And this time, I have to say that there are 3 bills out there which are critically important for the country. And those are the new Sanhitas, the criminal bills, the bills that are designed to replace the IPC, the Evidence Act. How will the criminal justice system work? Those bills had been tabled earlier. Then they went to the Standing Committee. The Standing Committee made some changes. And after that, the bills have been reintroduced. Now, are we going to see a lot of debate and discussion and how those bills should actually be operational? Should further amendments come in at some point? How can we get the criminal justice system to work in a faster and a speedier and a more efficient manner? But frankly, we don't know, because there are going to be disruptions, and that entire question is going to be a little bit up in the air. But what should those bills actually contain? But who better to talk to? Sujeet Kumar, who's an MP, who's a member on that standing committee on Home Affairs, which has actually been making suggestions about the criminal laws and the new bills that have actually been, or the new Sanhitas that have been put back into Parliament. But Sujeetji, thank you so much for joining us. But before I ask you about the bills themselves and what criminal law does, the incident that happened in Parliament, I just wanted to get the sense of from you, and how have parliamentarians reacted to that breach in security that we've just seen in Parliament?
Vikramji, it's extremely concerning members cutting across party lines have expressed their deep concerns. It's a serious breach. We are often told that there is a 7-layer security in the parliament premise, but what happened on the 13th of December is a grim reminder of the fact that no, the security arrangements were not foolproof, and there should be a thorough investigation, thorough review of the security arrangement. And I hope that such an incident is not repeated. We shudder to think, had there been cyanide or some other poisonous gas in that gas canister, imagine what would have been the consequence, or if there were RDX in the gas canister. So this is very, very concerning, Vikramji. Hope good sense prevails. But as I see, it could be a blessing in disguise. This could lead to thorough revamp of our security apparatus.
And of course, the fact that this happened at all, because you're right, there's supposed to be really intense security, and how they got the pass, how they were able to come inside, how they smuggled in canisters in their shoes. You're right, it could happen again.
Yeah, this is why I don't want to make it political, but I really hope that the government takes extreme, which I think they have taken extreme note of it. And as I said, there could be a silver lining to this. This could lead to a complete revamp of the entire security arrangement, not only the parliament, but in every sensitive installation in the country.
All right. Let me turn my attention now to the new Sanhita. So the fact that the criminal laws needed to be changed, they go back hundreds of years, is something which was very clear cut. What were the standing committee's main views on these new Sanhitas, and were there any other changes that you think may still come via amendments or other such systems?
So Vikramji, there were a couple of key objectives behind these 3 new bills. As you rightly pointed out, the original bills dates back to 100, if not more, 150 years. IPC 1860, Evidence Act 1872, CRPC originally was 1861, then had a revamp in 1973. So most of the provisions in these bills were of the colonial era, and they were not in tune with our modern legal framework. So there was a need to overhaul the entire criminal justice system, particularly in the context of the technological advancements, in the context of the reality of the congestion of Indian courts. Today we have over 60,000 cases pending in the Supreme Court, over 4.5 crore cases pending our trial courts. So these are humongous numbers. And also the fact that Supreme Court and many law commissions and other commissions have time and again pointed out that our criminal justice could be reformative rather than being punitive. So these were the key objectives behind bringing these 3 criminal law reforms.
But one of the questions, I guess, which I'm sure the standing committee also looked at is, as you correctly said, if you look at the real problem in the Indian criminal justice system, it is pendency, of course, a large number of cases, but above all, delays. The fact that you can have it could be, you could be investigating a crime for decades before a FIR is filed or a charge sheet is filed. Trials last for decades altogether. People languish in jails as under trials for years before they are suddenly proved to be innocent. That crucial problem of delay, it's probably the single most important reform measure that India has to still deal with. How will these new bills and the amendments help in that?
I think you have hit the nail on the head, Vikramji. I have been a strong advocate of completely reforming our judicial system and our criminal justice system. I do not claim that these new bills have taken care of all of this with regards to pendency of cases and clogging of our courts, but some efforts have been made. I can give you a couple of examples. Now, previously, there was no time limit as to when a magistrate could pronounce the judgment after the hearing is over. Today, the magistrate is, as per the new law, mandated to pronounce the judgment within 30 days after the hearing is over. Previously, the time limit for the framing of charge was not there after the issue was taken up by the court. Today it's 60 days. Previously there was no limit as to how many adjournments the lawyers could take. Of course, it was the discussion of the court, but easily, I'm a lawyer myself, and easily the court granted 4 or 5 adjournments to every lawyer. I guess there is some improvement in this aspect, but certainly more needs to be done.
So just looking at the things that could, for example, be done, I know that industry, for example, has been pushing for a long time to say you should have things like a statute of limitations. You can't keep things going forever. There has to be a time limit, 5 years, 7 years, 10 years, after which you say you've not been able to take cognizance of the case should be dropped. This should be applied to old matters also. Surely all IOs can be encouraged to look at, their cases that are piled up, or the courts. If something is 30 years old or 25 years old, or in some cases, God forbid, 40 years old, should just be done away with so we can focus on important cases.
Well, Vikramji, while we are discussing this, I must also add that yesterday, the day before yesterday, Rajya Sabha passed the repealing and amending bill 2023. This is in addition to the Jan Vishwas bill, which was passed during the monsoon session of the parliament, and I was also part of the Joint Parliamentary Committee, JPC, which looked into the Jan Vishwas bill. Both of these bills are extremely commendable in the sense that they have done away with many obsolete and outstanding laws that remain in our statute books. I mean, there were many laws, many legislations which were actually funny, which were actually amusing. And thanks to this government, if there is one thing which I would like to compliment this government for, it is the fact that they have really taken the effort, or made the effort to remove some of these very archaic, obsolete old bills.
A lot of what is there in the Sanhitas is forward-looking. But do you think whether it's the Jan Vishwas bill or the new Sanhitas, that should some of it be backward-looking also, so that those old cases, the pendency of cases can be reduced to some extent?
Well, one of the aspects of our justice system is that any law can only apply prospectively. It cannot apply retrospectively. So for all the pending cases, these bills, I'm afraid, will not apply, even when they come into effect. But I think the fact that technology has been given a lot of prominence, usage of technology in dispensing justice has been given prime importance under these new bills. I think that will really help us to reduce dependency. Technology has penetrated pretty much every aspect of human lives except for the legal fraternity. It's the last frontier. So to that extent, I think these bills are really forward-looking.
There's some concern about some of the bills that are still there. UAPA, for example, PMLA, some of these bills which have got very harsh provisions, right, which are capable of being misused. A lot of human rights and other activists have expressed concern about that. Do you share that concern? And how do you make sure that there are laws that are stringent enough to take care of things like terrorism or sedition? For example, in the terror definition now, economic security has also been added. Now, there'll always be concern that can it be possibly misused? Somebody doing, you're not paying your taxes. Is that attacking the economic security of India? So suddenly a terror clause is put into some FIR or charge sheet somewhere. How do you prevent that abuse?
Well, certainly any law could be misused for that matter. Why only the 3 bills or PMLA or UPA? I actually welcome the fact that terrorism has been included in the BNS, because there was no definition of terrorism in the IPC. But the first version of BNS had terrorism defined very vaguely. So the committee had given its recommendation that this is an extremely wide and vague definition. This should be made very specific, which the second version that was introduced in Lok Sabha 2-3 days ago has taken care of. Now, why I say I welcome this, because you had state-specific laws. For instance, Maharashtra had the Mokaka Act, you had the UP Act, the Gunda Act, and but you didn't have a central act to take care of terrorism or organized crime. Now you had instances where criminals could commit offense in a state with a state-specific act, and then move to a state which doesn't have similar legislation. So it was extremely difficult for the law enforcement agencies to handle such cases. So this is why there was a need for a central act.
Okay, I'm going to now get into the subject in slightly more detail. And there's a reason for this. You've heard from us on the India story. So many reforms have been done. So many positive things have been done. But fixing the judicial system to some extent, speeding it up, reducing pendency, perhaps the single most important item on the reform agenda. And that's why on the India story, we're going to keep coming back to this theme. Two really special experts now joining us to shed light on what has happened this week and what perhaps still can be done next phase. It's an ongoing process. Mr. M R Madhavan joining us, president of PRS, doing a lot of work on all legislation and how it pans out. Pinky Anand, of course, senior advocate, former Solicitor General of India. So thank you both so much for being with us to shed some light on it. Mr. Madhavan, why don't I start with you? When you take a look at the Sanhitas as have been again reintroduced, presumably if the din quietens down, may well be passed fairly soon. So we're going to have a completely new set of criminal laws in this country now, which is interesting because all of us have been complaining for 20 years that existing criminal laws are bad. So the new laws, better, worse than the old ones, and still changes that need to be made?
Yes, in a way, changes be made for the simple reason that we are saying there's a complete new set of laws. But if you look at them, and for good reason, 90% of it is the same across the three. Some of which ought to not change too much. For example, the Evidence Act is by and large, the only changes were for the electronic evidence and how to handle that. And most of it has been working well. So that's fine. But I would say, especially in terms of the new IPC, which is the BNS, a number of things are still using the same philosophy which was in the 1860 Act, which had a particular way of looking at criminal law, which I would say is more a retributive or a penal law rather than a reformative law, and which included a number of things which today you will say are civil cases. But just to give you a quick context, which when I was doing research, I found it interesting, that the British made the law, and England itself, they had death sentence for pickpocketing until 1808. They had death sentence for theft until 1832. So it's in that context that those laws were made. They're not 21st century norms. And of course, we have changed a number of them, but it still remains primarily punitive, though they have included the concept of community service without defining or explaining what that is.
All right. Pinky, that point about making it more reformative rather than punitive, don't put everything which could be civil into criminal, is obviously of direct relevance because there's this other statistic. I'm going to put it up on the screen right now. That just a sheer number of people who are actually crowding Indian jails, right? And 90%, 80% in some cases are under trials. Our jails are packed with people who don't necessarily need to be there. Some of those could have been civil matters. Some of those are cases which may not be really requiring jailing. And then you have the question of jail not paid. What do you make when you look at these new bills in that context?
That's an interesting phenomenon. And what Mr. Madhavan just spoke about reformation and retribution as two theories. I mean, criminal law has that theory across board. And also your statement about, the jails being crowded and the kind of number of cases. But ultimately, let's understand what criminal law is about. So criminal law in principle, in jurisprudentially, is meant to be something which sets down a standard for people to follow. And on failure to do so, action is taken. And increasingly, in fact, I'll support what Mr. Madhavan is saying to some extent. For example, in Companies Act, a number of provisions of penal provisions which were made for jail were ultimately amended on to being punitive, as in monetary punitive nature. But reformation is a good theory, principally, and something which should be followed. But at the same time, what we do need to act, and in particular, if you see some of the kind of offenses, let's say terrorism. I'm just taking that as a starter. Now you have economic offenses, you have terrorism. You do have to deal with them with a stern hand. And unfortunately, until you set down that standard, it doesn't seem to work. So the principle is not that you reach towards penalty or retribution only. The idea is to lay down the standard, whoever violates it, what action. I'll give you an example. For example, of cars, speeding, challans, as simple as that. I mean, until you put down a fine which is somewhat prohibitive, at least. I mean, even now, frankly, it isn't prohibitive. But it has gone up to a larger extent. I was party to those. The toll tax violation. You don't do that, people are not likely to follow. Unfortunately, we seem to still follow a principle that we have to be made to follow the law, not that because there is a law, we will follow it.
So, Mr. Madhavan, changes that you might, I mean, presumably this is an ongoing process, right? I mean, the standing committee, as you were just hearing, has come and made some suggestions and these new bills are out there. Presumably it's going to be an ongoing process. What would you do, therefore? As Pinky very correctly said, sometimes you need a danda, because if you don't have a danda, people are not going to follow the law, right? So how do you match the necessity to have a danda, which makes people follow the laws, with some of those other things? Don't overcrowd jails, principles of liberty, bail, not jail, other sort of things. So those are the liberty aspects of this entire question as compared to make people behave aspect of it. What changes would you still make, if any?
Some of the things which have been brought in, I'll just give you one example. So there was an amendment about, I think, 2006 or so, which said that if anyone has, in under trial, has served half the sentence, maximum sentence for that, would get bail. I mean, more or less like a default bail, though the public prosecutor could object, etc. Now they've added a proviso to that. They've done two things. One, they have said that if it's a first-time offender, then 1/3, not half, you can let that person shall get. But they have added that if the person is charged under more than one offense, then this is not available. Now, we all know that everyone is, I mean, for anything you do, significant, the charge sheet does mention more than one thing. So which effectively reduces the chance of people getting bail. So why are we not actually making it easier? And of course, we are not talking about, I would say terrorism is an extreme case. I mean, we can't be thinking of criminal law.
Although having said that, part of the problem with laws like UAPA and others is that the charge of terrorism, that's the charge creep that people talk about. You put terrorism into every second FIR. I mean, not every second, but you use terrorism sometimes when it is not really warranted to have terrorism. Same is true with the charges that are put into the charge sheet. Sometimes excessive charges are put in to deny bail and to keep people in prison when that is not really warranted. And you must be experiencing this also. Mr. Madhavan?
Yeah, so frankly, I don't practice law, so I'm talking more in conceptual terms.
Yeah.
So if your attempt is to say, by saying somebody will get bail if they have served half the maximum sentence, then why do you have a proviso which essentially negates the main item, which means that people will not actually get, because it's almost certain that in most cases they'll be under more than one. So either you say they won't get.
Okay, let me ask. Fine, fair enough. Actually, let me throw that point to Pinky, because as additional Solicitor General not that long ago, it was her job to actually send people to prison and make sure they stay there for a while. Pinky, the entire concept of bail, not jail, this is obvious. I've been hearing this debate ever since I started my journalism career 30 years now. Bail, do we need a separate bail law? Do you need to have some of the provisions that Mr. Madhavan was talking about to make it, easier for first-time offenders and others? And how do you prevent the problem of charge sheet creep, where people are being charged with UAPA where maybe it doesn't really warrant a terrorism, charge in there, or that when the FIR you suddenly put 10 charges, of whom 2 may be warranted, but the other 8 are just there to make sure that the person doesn't get bail?
See, I wish there was an absolutely easy solution, but let me try to just handle this from a couple of levels. So as a practicing lawyer and having seen a few of these things, I do think that the current amendments that are proposed, or rather the current provisions in the bill, which provide for bail on having a certain amount of trial time there or under trial time, is still very significant. You may have multiple charges, but you do get the benefit. And frankly, we can't always negate charges by saying there are excessive charges. If a person has committed a crime which comes under 5 offenses, so be it. But you are providing for the higher, and this is very typical. In fact, there is also a question of concurrent sentences and all, which we have simplified in the current provisions to allow people to get released. The whole idea being that don't put people behind bars forever, so therefore simplify that process. as far as the charges and all are concerned, and I do think we need another provision. See, while you were talking, there are certain acts which are, of course, non-bailable. The provisions are non-bailable. So invariably, they come in and people tend to use them. Unfortunately for us, again, systematically, people who want to violate the law utilize the provisions of law, and therefore sometimes provisions are put in or allegations are made ultimately under an act which is non-bailable. So I think there the role of courts has to come in.
Look, we know what the problem is, and it's one of the biggest issues in India. The fact that the judicial process is as protracted as it is, 5 years, 10 years, 20 years, it's like this is really going to be a bottleneck if India is going to become one of the fastest growing economies in the world, third largest economy. You can't have the judicial system working like this. So are there legal changes that you would make? So one is to say, okay, the court should work faster and have more judges and the rest of it. But when it comes to the laws, could something be done in the laws themselves to make them more amenable to speedier justice?
So I would actually, again, come back to it. We should have clarity, firstly, on deciding what can be civil cases with even monetary penalties and what can be criminal. So that takes away a lot of your caseload, where the civil cases pretend to be criminal and come into the system. That's one. Second is, there is this confusion about who can, not confusion in the terms of, the law is clear about it. I think conceptual confusion on compounding. So there is a number of offenses where, let's say, I am the victim, I have the right to compound. For example, cheating. If I have made a complaint on cheating, I am the victim, I can compound. Now, if I go back to say that, when do we say it's a criminal? Criminal offenses when it's against society at large, public at large. Okay, it's not against a single person, it's not a personal grouse. Okay, and that's why this public system takes over and the public prosecutor comes into the picture. Now, if as a private individual, I have the power to say maaf kar do, then should it be considered as, should I be given the power to actually say on if it's an offense against society to actually say chodo?
Last thought on that and speeding it. So in addition to changing the laws, I wonder if there can be laws or actually principles laid down for how the courts actually operating, this concept of adjournments, tariq pe tariq, stretching things on for years. Because let's face it, the delays and a delayed justice is the actual opposite of what justice should happen. Because if you delay something for 7-8 years, if you're an innocent person, it's hurting you because you're languishing in jail, whereas the trial is continuing. And if you're a guilty person, you're benefiting because you're saying by the time somebody catches up, the law catches up with me, अरे क्या पता 7-8 साल में कुछ भी हो सकता है. Witnesses will go, evidence will be buried.
No, you're right. So I think one of the primary things, in addition to what Mr. Madhavan and you were saying about, for example, appointment of more judges, filling up of vacancies, which is, of course, a peremptory thing that we do need to. And frankly, recently we've been doing a decent job of filling up the appointments as and when they happen, which is something quite speedy in comparison to earlier times. However, what I do think is important is we must set time limits. I think we need to set time limits to arguments. We do need to set time limits to adjournments. Incidentally, in law, there is a provision is you can't get more than X number of adjournments. But all said and done, adjournments are done. Now, for example, just take a separate system. Let's take UK for a moment. You have a trial set in, it happens. It happens in a couple of days and then ultimately dates are fixed. They happen on those days. So we must really stop taking this as a matter of practice, whether as judges, whether as lawyers, to say, I can take time when I want to. And time limitation also, by the way, which you were speaking about, is an essential component. The provisions are there, accepting and unless we really go into the past to an extent that we can, continuing offenses, for example. That's a different matter. Ultimately, you can't have a limitation for that. But where you can have a limitation, excepting for serious offenses, heinous offenses, economic offenses, whatever they might be in that category, which we can classify, we really have to put a time stop to it. We can't let the system go on. The witnesses are not available. The evidence is not available. Nothing happens. I personally have seen so many trials and appeals coming out of those happening where nothing is available. So ultimately, even if assuming it was a good case once upon a time, it's just not going to translate itself. So if we can do that, it is good. However, again, a problem that I will park on the last side to say there are serious offenses which cannot in any manner be put in the same fold and said, time bound won't happen. What if there is a scam, which there have been several scams in the country? They've been.
But you can always say there are exceptional circumstances, right? It can be an overall principle, and you can say in exceptional circumstances, XYZ happens.
No, you're absolutely right. I'm just saying, for example, 2G. I'm just saying for a moment. So you these kind of cases obviously will come on a separate periphery. But having said that, time limitation, a time for trial to be disposed of, bail to be given on certain eventualities, again, exceptional circumstances can always be classified and to even left to the discretion of the court.
All right. Thank you so much, Mr. Madhavan. Pinky, Anand, thank you so much for being with us.